them. But once I represent them, once I'm involved in their case, once they've expended money to educate me on their case, I'm their fiduciary. And I'm in a position where I have a hand up on them. I know their weaknesses, emotional weaknesses, monetary weaknesses. I know their case. It cost them money for me to, if I withdrew and they had to hire another lawyer. I have a distinct advantage over them. Now I tell them, guess what? I'm raising my rates. Never provided for in the contract, or provided for vaguely in the contract. The contract would read, I reserve my right to raise my rates as to keep in line with the customary standards. Customary standards of what? We had a case where the first billing statement in a similar situation, the first billing statement out raised the rates after the contract was signed. And that was their argument. I have a right to raise my rates. Be careful of that, because we exert a lot of influence over our clients, and in many situations, as Judge Evans pointed out, this is very emotional. We own them, we control them, and we shouldn't be able to use that against the client. If you're going to have rates raised, I would suggest the contract should read something like, I reserve the right to raise my rates no more than once a year and no more than 5% of what my rate was, or something that limits it, because otherwise I don't really think that's an enforceable contract. By the way, I get to raise my rates anytime and for as much as I feel like. When you do the fee hearings, usually what you will receive is the billing statements that were sent to the clients. But that's not the only method that a lawyer has to prove the fees. Anything that the lawyer has that has some reliability can be used to show what the fees were. If you're going to show costs, opinion witness fees, things of that nature, you have to be very, very specific on it. Subpoena fee, $50. That didn't do it. Who was the subpoena to? Maybe even why did you have the subpoena, although sometimes that would be fairly self-explanatory or would be testified to by the lawyer. Again, if it's not specific, messenger service, I don't think that makes it. That might first of all be overhead, but it doesn't say why you use this messenger service. If you have an expert who is valuing a business, and it says valuation of business, total time, 35 hours, bill $5,000. That didn't do it. The costs for professionals has to be as specific as the costs for the lawyers. So you still have to be able to look at those costs and say, are they reasonable? Are they necessary? In that line, you may also want to get to issues as to why was this issue before the court. You spent 12 hours briefing your objection to an appointment of a guardian ad litem when you had a custody petition on file and the judge thought it good to do that. Well, the judge didn't have any right to do it. Well, common sense tells you that it's going to happen if it's on the judge's own motion. It always does happen customarily, and you shouldn't have spent 12 hours briefing it. So look to the practicality of what are the issues that are being chased in the case. The Giroulet case, which is cited in your materials, is an interesting case because it says Section 508A allows the court to award reasonable fees and costs. The attorney's fee allowed should be fair to both the party required to pay and to the attorney requesting them. And again, that's my point. Balance it off as to what is fair to both of them. In reaching the determination of what constitutes a reasonable fee, there's a lot of factors that the court looks to, and will go, and the mediator should look to. And Rule 1.5 of the Illinois Rules of Professional Conduct sets forth some of those factors. Rule 1.5 is printed in your materials. Now, the Powers case says that the most important factor that you look at is the time that the attorney expended. So of all the factors, that is what they consider the most important, and a couple of cases said it should be given the same or greater weight than all of the other factors, than any of the other factors that you consider. So again, don't get so bogged down in the technicalities of it that you can't see the forest for the trees. When you look at the totality of the facts and the circumstances, that's what you determine a reasonable fee to be. What was reasonable and customary in Cook County, Illinois, for a domestic relations lawyer? Aha, but I'm not a domestic relations lawyer. I'm at a silk stocking firm, I'm a major partner there, and I bill regularly at $550 an hour, and my clients are happy to pay that. Well, too bad. The domestic relations attorneys in Cook County don't bill at $550 an hour. It's not reasonable and customary to us. The same would be true if they're coming from a different county to Cook County. You use the Cook County standards of what a domestic relations lawyer would charge. In the same line, you use the Cook County standards for what would a domestic relations lawyer reasonably do in a case. How would they reasonably handle the case? Would they take that motion? Would they brief the objection to the appointment of a guardian ad litem? And so you can look to the custom. To the lawyers out there, the judges in these cases are allowed to tap their own experience. They don't live in a vacuum in this. They can tap the experience of the case. They can tap their experience of what happens in these cases. You can use your own experience. To the lay people, as you get more experience, use your own experience in helping to determine this. These are all the type of thing that is a reasonableness standard, and you determine it. In these cases, absent abuse of discretion, the trial judges are affirmed in what they determine to be reasonable. One of the things that we see in domestic relations, and we had it, is the fee shifting. And so, for example, the wife's attorney is looking for fees from the husband. A case came down called In Re, the Marriage of Powers, that said, and the attorney not only wanted some fees, but also wanted to be paid for the time for preparing the fee petition against the husband and going after him for fees on behalf of his client. The Powers case said, yes, you can do that, because that's something that is brought under the Illinois Marriage and Dissolution of Marriage Act. You're entitled to it. But that was fee shifting. Now, arguably, you could say when I'm going after my own client under 508, that's brought under the Illinois Marriage and Dissolution of Marriage Act also. Don't get caught on that. I don't believe it for a second. I don't believe you should believe it. One of the factors that we look at is benefit to the client. When you're suing your own client for fees, you're rendering no benefit to your client. You shouldn't be compensated for it. But I've heard a lot of lawyers argue, Powers case says I'm entitled to fees for fees. Don't fall into it. There are a lot of cases, the case of Muller versus Jones is one of them that I cite, that says the time required for filing attorney's liens against your own client, it's not compensable. You can't be paid for suing your own client. Now, the great conflict may arise if you did provide for it in your fee agreement, that if in the event I have to chase you for fees, I'm entitled to reasonable attorney's fees for doing it. You're on your own on that one. Probably that would be allowed, again, as long as the contract was an arm's length contract, and as long as the fees that they're asking are reasonable. I would guess that they would technically be entitled to seeking fees for fees. But I've seen too many times they've argued Powers. Powers is not the reason why you would give fees for fees. Look to the quality of the services provided. Look to the results obtained. If you got a good result for the client, it may entitle you to your fee. May entitle you to more than your fee. No. It's a factor. And if the factors apply and you're happy with the factors, give them their fee. But it doesn't cause for an enhancement. Now, when the lawyer takes a case and doesn't get a huge result, but proceeded in good faith, should we penalize them because they didn't get a good result? If they proceeded in good faith, you don't have to punish them just because they weren't successful. If they proceeded in bad faith, or they brought motions that weren't customarily brought, the 12-hour objection, and they didn't prevail on that surprise, you may say, no, that was not reasonable and necessary that you filed that. But again, Note the distinction. You're not shut out for fees just because you fail in a specific motion or fail in the case. You could be shut out for fees if the motion wasn't warranted. Look to the benefit received. If somebody received at trial greater benefit than was offered in settlement, or what they offered in settlement, that could be cause for giving them their fees. Give them a bonus? No. This is not about bonuses. If they did worse, the judge told them, take the settlement the other side offers. It's fair. It's more than fair. I want my day in court. My client's entitled to way more, Judge. Doesn't get it. Consider it in determining the fees. But again, if they're in good faith, consider that too. Look to the novelty of the issues. Was this a complex case? Was it a novel case? Was it important from a family law standpoint? Was it a difficult case? If it was a run-of-the-mill case, you've got to say no to all of those factors. And then you weigh your judgment accordingly. Were they legally complex? Were they factually complex issues? That would entitle you to the fees. You may see issues of dual rates, court time, office time. There is no prohibition against not having dual rates. You can have the same rate for both court time and office time, assuming, of course, that that rate is a reasonable rate. So, and the case is Gibson versus Barton that's cited in your materials. There's no requirement. On the other hand, many lawyers have dual rates. So, for example, the lawyer might charge $200 for office time and $250 an hour for court time. Now, having done that, and they sit in court and they wait for that status, and they're waiting there for an hour, and they step up and they say, Judge, we're really not ready. We're not finished with discovery. Can we kick this case for 30 days? If billed at all, that better be billed as office time, not court time. The higher rate encompasses the idea that a greater skill is required for litigating over at the courthouse, for advocating over at the courthouse, not for mundane court appearances for routine matters. The issue of sitting around the courthouse in and of itself may be suspect. Could you bill a half an hour for a status that lasted 6 minutes? Maybe. Well, I walked over there, sat down, I talked to the other attorney perhaps. I waited for my case to be called, and that all took me a half an hour. 2 hours. That clerk, she was so rude, she didn't call my case till 11:30. I don't think so. I think you should be bringing something else to work on. Well, we talked about the case. Yeah, that's it. We talked about the settlement of the case the whole time. Well, that's what your time entry should be then. While at court, we discussed the settlement of the case, and that's where the specific entry should come in. Look to the skill and the standing of the attorney. Lawyers bill anywhere from $100 an hour to $400 an hour in Cook County. 400 is a little steep, but look to what qualifications do they have to bill like that. If they're billing at $350 an hour, do they have a lawyer billing, an associate billing at $200 an hour for the more routine things? Should be. They should only be brought in for the heavier matters, for the settlement conferences, for the legal arguments in the court. Look to the amount of what's at stake in the case. If the marital estate is worth $100,000 and the lawyers have packed in their $50,000 together, something's gone wrong. And you can weigh the value of what was at stake versus what they were doing. And again, that goes to, was it reasonable? Was it necessary to do this? Look to the degree of professionalism. If the lawyer worked with the other attorney, got things through quickly, that lawyer ought to be getting all of their fees for helping get that through. That should be a factor that you look at. Sometimes in a hearing, you'll hear the objection, attorney-client privilege, and it's raised by the client who doesn't want to pay the fees but doesn't want and the lawyer to be able to testify. Or you'll hear it raised by the lawyer who for some reason wants to withhold information. It's not the lawyer's privilege. It belongs to the client. Client can't fight the fees and raise attorney-client privilege. So there's no attorney-client privilege in these fee disputes before you. An attorney can look at a document prepared by a lawyer in his office or by that attorney to refresh their recollection as to what happened in a case. There's been cases that have had that issue brought up on appeal. The court says that they can look at it. The best evidence rule. Objection. Those aren't the original records. I'm objecting to that coming in or the testimony. Don't worry about that. The testimony, the evidence of the attorney's fees is up here. Everything else is just a record of it. The best evidence rule shouldn't apply. If there are documents that reflect time put into a case, you should look at them. You should consider them. Again, once you have looked at all these factors, this isn't about enhancement. The case of Malik says, in determining the reasonableness of fees, the court should consider all of the factors discussed and determine what weight or value to assign to each factor. It can then enhance the fee by adjusting it upward or decrease it by adjusting it downward. However, it appears that a court may not enhance a fee to an amount in excess of the figure, which would be the result of multiplying all of an attorney's hours by his hourly rate. Can't give him a bonus in these cases. There are some very limited, very specific situations in which there may be a legitimate bonus, but that's a rare situation. Again, look to the engagement agreement. Under the new statute, the court says, the court shall first consider the written engagement agreement, and if the court finds that the former client and the filing counsel, pursuant to their written engagement agreement, entered into a contract which meets applicable requirements of the court rules and addresses all material terms, then the contract shall be enforceable in accordance with its terms, subject to the further requirements of subdivision C3. Before ordering enforcement, however, the court shall consider the performance pursuant to the contract. Any amount awarded by the court must be found to be fair compensation for the services and must be reasonable and necessary. So again, keep an open mind. Don't get pigeonholed into I heard that duplication of services were wrong, so therefore I'm going to exclude all of those. Don't do that. Keep an open mind, and just keep in mind the two words, reasonable and necessary. Thank you.
Thanks, David. We're really fortunate to have David put these materials together and speak to us. I think he's thought more about matrimonial attorney fees issues than anyone in Cook County. For those of you who are not matrimonial attorneys, this may seem like a lot to digest, but remember that the chair of your panel is a matrimonial attorney who will be more familiar with these rules than you. So although you should not rely on his or her opinion necessarily, you should feel free to ask questions if you have questions about these specific areas. We're going to wrap up hearing from Eddie Manolis, who we're also fortunate to have. I think he's probably decided on and arbitrated more fee disputes in Cook County than anyone else, and he's going to walk us through some other things to think about as you're handling these cases. Eddie?
Thank you, Linda. I am glad to see so many people here. As the past chair of the Professional Fees Committee of the Chicago Bar Association, this is an area where we do a lot of work but need a lot of help. So I'm just taking this opportunity to ask you to volunteer to work with the fee committee, where we hear fee issues raised by clients usually who file complaints with the committee and seek guidance from the committee on fee issues. And we have a very small committee. We do a lot of work, but I think it's very rewarding work personally to help clients, to help the attorneys, to make sure that people get a better understanding of the legal system and how fees are charged. So if any of you are interested, I would request that you contact the CBA and find out when the meetings are. I believe they're the 2nd and fourth Thursdays of the month. You're not required to go to all of them. But within this process, we do hearings, we do arbitrations, and that's pretty much where my experience has come into this. I do not have a matrimonial fee background or training. I do commercial litigation, but that hasn't stopped me from going ahead and hearing about half of what we have in the fee committee, which is matrimonial fee disputes. They come up a lot. There's a lot of emotions, as Judge Evans was saying, and the parties have emotions between the litigants, between the husband and the wife, and that pours over in with the attorneys, and it gets compounded and made doubly worse by the attorneys not providing an open channel of communication with the clients. So eventually, and unfortunately, you end up in a situation where you have these fee disputes and somebody is required to decide them. Within what I think I want to cover more is the procedure of what will happen at the hearing and what your roles will be at the hearing itself. I think David did a great job of covering the actual fee issues. I personally, he's got a great, I was looking at it at the beginning of this session, I've never seen it before, but his materials in the handout is great. I've always taken a copy of Rule 1.5 with me to every hearing that we conduct, and it's a simple outline, and you need this to look at it because within the context of fee disputes, you end up with a lot of issues that are not directly fee related, but which the client is complaining of, and I'll get to that in more detail. First, I want to cover, I handed out today a short, I was passed out separately, just a short outline of what I'm going to cover under the topic fee dispute resolution. And item 1 is the context of these fee arbitrations. Everybody's hit on it a little bit. We're implementing the provisions of the statute 750 ILS 5/508C4, which requires participation in an ADR procedure unless both parties opt out in Cook County. So unless both the attorney and the clients agree to opt out, it will go to some sort of fee dispute, and arbitration is one of the options that the Cook County judges wanted to provide litigants. And this is binding arbitration, which, as was stated before, there will be no real further appeals of. There is provisions within the Illinois Uniform Arbitration Act to vacate a fee award that's entered by the arbitration panel, but those are very limited. You have instances of fraud, perhaps, or some sort of wrongful conduct within the arbitration hearing itself. And so, as you perform your duties, I think you need to be very conscious of your duties within that limitation of the Uniform Code, so that you don't cause a situation where a client or an attorney who doesn't like your outcome, which is a legitimately ruled upon outcome, to go ahead and complain back to the judges or try to vacate the award. Because it is binding arbitration, both parties agreed to it. And one of the things that the Cook County judges will require when they agree to the arbitration is to sign the arbitration agreement itself, and that makes it absolutely clear to both sides that you will be entering this award, you will be deciding the facts, and you will be able to make all the determinations as to the reasonableness of fees, as to the conduct of the hearing, as to the taking of the evidence, and everything else that is necessary to perform your duties. Let me just ask, how many of you arbitrated cases before for either the Cook County mandatory arbitration or securities or any others? Quite a few of you. I have also done some arbitrations for Cook County and for the NASD, and I can tell you these do not look anything like those arbitrations. Many times they don't, because you have really, even if you have the attorney, you have both parties being pro se parties. You have an attorney who's representing himself, usually, and he has his stake in receiving his fee, and then you also have the inexperienced layperson, the client, who is there complaining about the fees. Sometimes they have very specific complaints, and sometimes they're very general and nebulous, and I don't like how much this attorney charged me. I can't believe we came out with a $12,000 fee in this. So what happens is, because you have really both interested parties here and a client that's inexperienced, you cannot rely, as you do in Cook County or in other arbitration processes, you cannot directly rely on the parties to provide you with all the information that you would need to make a decision. Sometimes it doesn't happen. It doesn't happen that way. Clients, as I say, can be very vague, and I think you have to take a fairly active role in trying to determine the reasonableness of the fee. And I think that should always be your goal within this process, within taking the evidence and ruling upon the admissibility of evidence, is to make sure you come down to that resolution of what is a reasonable fee. So going on to A, under the voluntary agreement to arbitrate reasonable expectations, this program depends upon the parties, both the attorneys and the clients, expecting that they will get a fair result, that they're going to have a full and fair hearing. I have fair hearing there. It should also maybe say complete, but a full hearing. That's an opportunity where both sides get to present their side of the dispute and get sufficient time and effort to go ahead and provide the evidence that they're given. They're also entitled to have the impartiality of arbitrators to make certain that the person making the decision will be impartial, will not be favoring either side, and going ahead, included within that built-in protections are Rule 6 of the CBA rules regarding disclosure and disqualification, Rule 6 and 7, and Rule 8 regarding communications. Part of being impartial is not sneaking out and talking to one side out in the hallway while the other side is there. You need to maintain impartiality. You need to make sure that you make disclosures if you know any of the parties or if you've had any relationships with them, and to preserve that impartiality of the arbitrators. Also included in there is Rule 13 regarding confidentiality. The parties expect that when they come to you and they open up to you, as David said, there's no attorney-client privilege in this. Everything that they say will be out in the open to you. You have to maintain your confidentiality. They shouldn't have to hear later that you were talking about their case with some of your buddies, and did you hear what this attorney did in this case? Did you hear what something else happened? All of that tends to distract and discredit the system, and I think for this system to work, you cannot have that. Otherwise, people will stop opting for arbitration, and it would be a real loss to Cook County of that. So obtaining the fair result really requires having the fair hearing and having the impartiality. There are, within the system, limitations which affect those reasonable expectations. The problem is you have an hour and a half to decide a case that might have been involving 100 hours of fees or 200 hours and several years' worth. All that has to be compacted down to an hour and a half. This requires a lot of control by the arbitrators in how the hearing will proceed and what will be presented. And that's your job, to try to balance